What is the latest Ripple update that will change the course of the trial? How exactly will it affect the court decision? How much will XRP cost after these events? Write your answers in the comments, but for now, we're getting started. According to Deaton, he does not anticipate that Judge Torres will experience a major delay in rendering her decision about the summary judgment motions. Attorney John E. Deaton is of the opinion that a decision will soon be made on the complaint brought against Ripple by the United States Securities and Exchange Commission. This information was made public in a tweet by the founder of CryptoLaw today, in response to inquiries about whether the release of the judge's decision on Dalbert motions gives any hints on the timeline for her summary judgment decision. In his capacity as a friend of the case, the CryptoLaw founder represents thousands of XRP holders. Deaton stated his uncertainty on the likelihood of severe holdups. The attorney said that the judge may hand down her decision as soon as tonight, or it might not come until a few weeks from now. According to what has been published today, the judge's order on the Dalbert motion indicates that she partially allowed and partially declined requests from both parties to strike out expert evidence. As the report highlights, XRP holders were the biggest winners as a result of Judge Torres striking out expert opinions that the SEC used to support its claims that XRP holders purchased the token with reasonable expectations of profits solely from Ripple's efforts. XRP holders were the biggest winners as a result of Judge Torres striking out expert opinions that the SEC used to support its claims that XRP holders purchased the token. It is important to keep in mind that the counsel for the defendant in the case said that the decision about whether or not XRP is a security might take a further 2 months. According to what Ripple's general counsel Stuart Alderody said not so long ago, there are 3 possible possibilities. It is possible that the court will rule in favor of Ripple or the SEC, or it may decide to go to trial. Deaton has said that the clarification of the SEC's contention that sales of XRP on secondary markets represent unregistered securities offerings is the conclusion that he would most like to see the court reach. Even if Ripple is ultimately unsuccessful in the lower court, owners of XRP would still be able to claim a huge win if the judge rules against the SEC's position on this issue. Ripple's general counsel, Stuart Alderody, has said publicly that the blockchain firm would immediately appeal its lawsuit against the SEC in the event that Judge Analisa Torres rules in favor of the regulator in her summary judgment decision. Yesterday, in an interview with Blockworks, Alderody revealed this information to us. According to Ripple's general counsel, there are 3 different scenarios that might occur in the ongoing legal battle with the SEC. The outspoken general counsel claims that it is possible for Judge Torres to rule in favor of Ripple in the summary judgment proceeding. Second, he said that the judge has the ability to determine that there are contested facts, which will be addressed over the course of the trial. Alderody said in his third point that Judge Torres could decide to rule in favor of the Securities and Exchange Commission if he decides to give summary judgment. In the event that this transpires, the general counsel for Ripple has said that the Silicon Valley technology business would not accept a victory for the SEC and will instead immediately challenge the matter before the U.S. Courts of Appeals. In addition, according to Alderody, Ripple is planning to take the issue all the way up to the Supreme Court if the Court of Appeals does not rule in favor of the blockchain business. The members of the XRP community gained confidence as a result of his assurance that Ripple will prevail in the lawsuit before the Supreme Court. Alderody predicts that the Supreme Court will find in favor of Ripple because to the safeguard it provides against the establishment of an administrative state. According to Alderody, I would be very convinced that this is a victory at the Supreme Court. Not so much because of crypto problems, but more because of the guarding against developing an administrative state. Citation needed it. In addition, the general counsel for Ripple has indicated that the much-anticipated summary judgment may take place before the month is out. Because of the lack of clarity over how regulations will be implemented, Alderody recommends that new cryptocurrency ventures do not start in the United States. According to Alderody, these new cryptocurrency initiatives have to be launched in a country that has developed laws that are applicable to the business. New crypto firms should go to a country where the regulations are clear, not light. Touch, but explicit, he added. New crypto businesses should move to a jurisdiction where the rules are clear. Because of this animosity, a number of crypto firms are mulling about the possibility of leaving the United States. According to a story from the previous month, Ripple CEO David Schwartz dropped a hint that the business would leave the U.S. if it is put in a position where it has no other option. In a recent interview with Bloomberg, Ripple's chief executive officer Brad Garlinghouse gave his support to Schwartz's statement. According to Garlinghouse, cryptocurrency firms are already moving out of the United States because of the country's failure to get its act together. He continued by saying that us crypto enterprises that operate abroad are not appropriate for the creativity of the nation. No one anticipated that the creation of the XRP coin in 2012 would set off the SEC-UVs. Ripple litigation, one of the most famous legal fights in blockchain history. Ripple was one of the biggest digital assets in the crypto industry before Ethereum was even a glimmer in VitalXI. For a long time, crypto news was dominated by the SEC's case against Ripple. Crypto aficionados have gotten desensitized to the fight over time. The fate of XRP, Bitcoin, Ethereum, and the whole cryptocurrency industry hangs in the balance of the CES lawsuit. Ripple blockchain is a distributed digital payment system similar to Bitcoin. When it was first introduced in 2012, Ripple's primary goal was to facilitate the rapid and cheap international transfer of multiple fiat currencies. The SEC has filed a complaint against Ripple Labs and its CEO Brad Garlinghouse and co-founder Chris Larsen. This is the official case that the XRP lawsuit refers to. In New York, the case is being presided over by Judge Annalisa Torres of the District Court. So what exactly are the SEC and its unmovable chairman Gary Gensler charging Ripple with? Every day, dozens of individuals buy, sell, and trade cryptocurrency tokens on secondary markets. Why should XRP be singled out for such heavy SEC regulation? In 2020, the SEC filed charges against Ripple Labs, alleging that the company had raised over $1 billion via the sale of XRP coins, making it the largest regulatory case in the cryptocurrency sector to date. If you've been involved with cryptocurrencies for more than a week, you're undoubtedly aware that ecos like this are widespread. The SEC has a major problem with the sale of XRP coins by Ripple Labs and its executives because, as they see it, these sales constituted unregistered securities offers. According to the Securities and Exchange Commission, SEC, XRP is not a currency but a security, instead, making it subject to applicable securities regulations. According to the SEC, Ripple's CEO and co-founder were also less than forthright over the course of the transaction. They claim that Garlinghouse and Larsen broke federal securities laws by making false and misleading claims regarding the XRP coin and by failing to formally register the transaction. In conclusion, Gensler LLC Company assert that Ripple Labs had knowledge that XRP should be classified as a security but deliberately withheld that information from its investors. However, proponents of Ripple maintain that XRP is a money and not a security. Thus, it is exempt from regulation under federal securities laws. The XRP coin is not a security under Ripple Labs' definition. While XRP is a currency and not a security, Ripple denies the allegations made against them. Ripple claims that the SEC's incorrect classification of the XRP coin and the XRP as an unregistered security sale are at the heart of the whole legal dispute. Ripple, to rub salt in the wound, asserts that the SEC's contradictory approaches to cryptocurrency regulation stifle a dynamic and forward-thinking sector